Good evening, Western Standard viewers, and welcome to Hannaford, a weekly politics show. It is Thursday, August the 28th. Last week, an Ontario man was charged with aggravated assault and assault with a weapon after he defended himself in his home against another man who had broken in. This famous case involves an intruder who was allegedly stabbed and remains in hospital. Canadians coast to coast are deeply concerned that the homeowner was charged. Do Canadians not have a right to defend themselves and their homes against intruders? With me today is Hatem Kheir, a constitutional and criminal lawyer whose work is funded by the Justice Centre for Constitutional Freedoms. Welcome to the show, Hatem.
Hi, thank you for having me.
Hatem, let's cut to the chase. There are two questions here, it seems to me, that need to be dealt with first. One, it seems like the message is that Canadians don't have a right to defend themselves and their homes. And who actually says so? Is that the police messaging that? Is that the accumulated wisdom of the courts, or is it Parliament itself? And then the second question is, to me, something seems to have changed. I can't imagine this case coming forward at the time that I started my journalism career a very, very long time ago. So what's your sense of what is going on, what is driving this apparently bizarre situation?
Well, to start with your first question, I think you're right to say that the message is Canadians don't have a right to self-defense, and that is the state of things. As for who's making it that way, it's it starts with Parliament, because the criminal code is their legislation. Criminal law is under the federal jurisdiction. And then more broadly than that, you could attribute it to the justice system as a whole. In terms of what's changed, it's a combination of factors. So the criminal code was amended back in 2012 to make the current rules for self-defense as they are. And the rules turn on reasonableness. It's an assessment of reasonableness. And that decision is ultimately going to be made at a trial by the jury. The jury is made up of 12 regular people. And so what is reasonable ends up turning on what people tend to think is reasonable. Taken more broadly, though, it's affected by the judge's jurisprudence on what's reasonable. And then even, going right back to the beginning of one of these charges, it's affected by, or it's at least the fact that situations like this arise turns on the fact that there's police who are laying the charges in the first place. So they show up to the scene, they assess what happened, and in their view, it makes sense to lay charges against this individual whose home was just broken and entered. And then it's in the hands of prosecutors who choose to prosecute those offenses as opposed to diverting them or withdrawing them. And then that leads to it falling into the hands of the court and then ultimately the jury.
But I think so many of us feel that there is something about somebody invading your property, your space, that's deeply offensive. It's out of all proportion to the actual loss that you might incur. It's sort of dishonoring, and it makes people angry. And it seems that the legal system is saying, no, you shouldn't be angry. You've got to be reasonable about this. And I wonder where that line of, perhaps you disagree with my analysis, but if you do agree, then how did that line of reasoning enter the legal system? Who did it serve?
Well, to go to your point about the offense of having someone break and enter into your house, the law historically, taking a broad view, isn't ignorant of that fact. When it comes to search and seizure law, the court recognizes that a man's home is his castle. When it comes to let's say sentencing someone for breaking and entering, the court will absolutely recognize the harm caused by that sort of violent intrusion into a person's space. And then when it comes to self-defense, historically, the court has recognized that a person isn't obligated to retreat within their own house. Now, that said, I don't completely disagree with the premise of your question. I think you're right to point out that there seems to be a disregard for that when you see a case like this come through the court system, and this isn't the only one. There have been others in recent years. I think part of what's happening is an over-willingness on the part of police to charge and then let the courts figure it out. And so, they see a person who did commit, by the letter of the law, they did use force against another person. So if it's not self-defense, he would be guilty of, let's say it's assault or assault with a weapon. And so they lay the charge, and then if he has a defense, they leave it to the courts to sort that out. The problem with that, and I think what offends the sensibilities of probably a great deal of Canadians, is that there's a punishment in the process. If you're charged with a criminal offense, it'll take years, perhaps it can range from a year and a half upwards to 3 years, depending on the nature of the charges and the procedure used, but it can take years to resolve. In the meantime, a person is dealing with the stress of the potential criminal conviction that results, the criminal, the possibility of a criminal record, the potential of jail time. In situations where the self-defense ends in a homicide, there's a pretty stark reality that's facing this person, where they could either walk free at the end of this trial or face life in prison. And then even if they get acquitted, they'll have spent thousands and thousands of dollars in their own defense. And I think people see that and probably rightfully think that entire process should have been avoided if the situation clearly appears to be self-defense.
Now, you say that the discretion rests with the police, and that, of course, is the case, but there seems to be a willingness to just throw the book around and let the courts sort it out. Don't think the police always thought this way. Is this anything at all to do with the fact that the police have had bad press over the last years, often at the hands of woke Canadians, and they just don't particularly want the aggravation? So instead of making a decision to not charge, for which they might be criticized by all the usual suspects, they take the approach you've described. Give it to the courts, let them sort it out. Too bad for the fellow, but it's not my money. Is that how it works?
I'm not a police officer. I don't know exactly what the cause is, but my suspicions align with yours. I think it is, if they lay the charge, I think it's arguably out of their court at that point. They can direct the responsibility to other parties in the justice system, the prosecutor, and ultimately the court. And perhaps it makes it harder to fault them for the decision. Whereas if they do decide not to lay a charge, the buck stops squarely with the police. No one else in the justice system has the authority to then intervene and lay that charge.
Well, it has always been my understanding that the police are very responsive to political direction. For example, if a politician holding office is very concerned about drunk driving, then the police will get that message and they will be tough on drunk driving. But it might be something else, in which case they'll be tough on that. This is not to say that police routinely ignore offenses that are not politically motivated, or I should rephrase that are some politician's pet project, but they certainly will respond if somebody makes a point of saying, we really want you to care about this. So is perhaps the way to deal with this kind of thing to put politicians in place who actually have an understanding of what it means to be awoken in your own home to find an intruder there, and that you do the reasonable thing. I mean, Danielle Smith, Premier of Alberta, commented at one of her town hall meetings that, if you don't want to get a night, this is a paraphrase, she didn't say these very words, but this was the gist of it, but if you don't want to get beat up, don't break into somebody else's house. Well, that seems reasonable. Now, a politician who feels like that, does she have any power to influence the way the police handle these cases?
There is a level of independence between police and the political sphere. That said, I think police forces, generally speaking, don't want to be the subject of negative press or negative public attention. So I think a shift in the public's view, the way public pressure gets directed, is an important part of shifting the culture at the level of the police, at the level of prosecutors. And politicians are a part of that. They're a part of that general climate that will, I think, nudge police in the right directions. But then more importantly than that, if we're discussing the responsibility of politicians in all this, they should exercise their political power to align both the letter of the law and its implementation in a way that aligns with a defense of people's rights to life and to defend their own lives.
Okay, well, I'm going to come back to that point in a moment, because really, when you're getting down to that level of detail, you're talking about the provincial governments. The Canadian code, criminal code, is what it is, but it's administered at the provincial level. But first, I want to come back to what you said about a proportional response. I wonder what is actually possible. Let's say it's you who's awakened in the middle of the night to find somebody in your house going through the drawers, or they've got the TV in their hand and they're on the way out the door. You don't know who they are, and you don't know what they want, or how much they want. You don't know if they're going to run away when confronted, or whether they will come at you. In the Kawartha Lake case that's making the headlines, the intruder was supposedly on his own, but he was wanted for other offenses. So there's a dangerous man in the house. As the person who is seconds away from being fast asleep and is just trying to make sense of this, how would you know that? How would you know to think about it? Is there somebody else with them? Do you know? Are they by the door to your children's bedroom? What will they do next? You don't know. In other words, you're supposed to make a response, apparently, that's proportionate to all these things that you don't know. And your life and the lives of others who depend on you for protection depends upon you getting it right in a split second. So what do the police advise? Call, cower, and wait. I've heard it expressed. To me, that seems to place a tremendous onus of forbearance upon the homeowner. And you say?
I think you're right with maybe a couple qualifications. So in terms of the ultimate resolution by the court, I do place a deal of trust in juries to make the right call. It's regular people who are tasked with deciding whether or not the use of force was reasonable in all the circumstances. And for the most part, I think juries are capable of getting it right. That said, the court, or I should add, the court has directed also that people in a self-defense scenario aren't required to weigh to a nicety. That's the term used by the court. The amount of force that they use. The problem with cases like this, again, or to use an example that's actually run its course through the courts, there was an individual in Hamilton named Peter Kill who engaged in lethal force when someone had entered his property. There was also an individual in, I believe, Manitoba, Stanley, who used lethal force. He was ultimately acquitted. So in those cases, take the Stanley case, the individual was acquitted at the end of all of it. So you could say the law got it right, but perhaps he shouldn't have been charged in the first place. And that's, at that level, the message that is being sent, if he is in fact being charged, is that perhaps he shouldn't have used the force, or he should have been more restrained in using it, or else just be prepared to be put through the ringer of the legal system after he does use it to defend his own life.
Well, I guess there's a slight difference. The Manitoba case, was it Manitoba or Saskatchewan?
It might have been Saskatchewan.
Yeah. I'm not sure either. So, but there was a case anyway. And in that situation, I don't believe that the homeowner, the person doing the defending of his property, was actually awakened from sleep. And it's a different thing. To my point about the ability to make a decision to offer a proportionate response. If you've just woken up and it's all over in a second, you have to decide in a second what you're going to do. It's a rather different thing, even than when you are looking out of your kitchen window and see somebody interfering with property on your farm, which I think was the situation. These things seem to me to put a tremendous onus on the homeowner, one that the homeowner, as the entirely innocent party, shouldn't have to bear. And I suspect that you're not going to dispute that with me. But what I would ask you is, how can the provinces, the actual administrators of the justice, the people who pay for the policing, how can they actually deal with this so that this kind of situation, if it happens, doesn't happen very often, and it's not something that the homeowner has to sit there worrying about?
Well, we've, in response to this Lindsay situation, we've heard comments from both the Ontario and Alberta premiers expressing criticism of how this was handled. And so those provinces and any others can take the responsibility to change how the laws are actually implemented and enforced. Now, local police forces will have a measure of independence, and so it's up to them to take responsibility for laying charges in a more restrained, responsible manner. But with respect to the provinces, the ball goes into their court after the police lay the charges. So once police lay the charges, the discretion is out of their hands. It then goes into the hands of provincial prosecutors who are responsible for the administration of criminal justice. And for every province, this is going to be true. There are policies that guide the use of prosecutorial discretion. Prosecutors are necessarily tasked with making a call whether or not a charge is worth prosecuting. And if it's not, they can withdraw it, which leads to it evaporates essentially. Prosecutors will withdraw charges if there's no reasonable prospect of conviction, which makes intuitive sense. But they're not limited to that assessment. Prosecutors also are tasked with considering whether it's in the public interest to prosecute. The classic example might be someone who commits a crime, but really is having more of a mental health issue that can be treated. And so, for example, it can be diverted to a mental health route rather than a criminal route. And there's policies that the attorney generals will implement and distribute internally that then guide the application of that discretion for every prosecutor. And prosecutors have to work within those policies. So, for example, the province can set a policy determining when it's acceptable to offer a plea deal on a charge of impaired driving. For if a person breathes over a certain amount, or if they maybe if they've had multiple offenses, a plea will be off the table. So in that same vein, it's open to a province to make a policy decision and say it is not in the public interest to vigorously prosecute people who are making those difficult calls, those difficult decisions at 3 a.m. when they've been awoken by an intruder and use force to defend themselves. So the province can implement standards that they could ask prosecutors to look at and to make a decision in cases where someone's home has been entered in the middle of the night, whether prosecution is really in the public interest, and if not, to withdraw the charges.
So that would rest with the office of the Attorney General in each respective province.
That's right.
And so then the political heat that the police are trying to avoid would land right there on that elected individual who has his own incentives for dodging it, I guess.
Or incentives for claiming the praise, right? If people really are upset at this, then there's an opportunity for a politician to do something popular.
So that's actually a good point. In respect to are we worrying about something that doesn't happen very often, or are there actually a lot of cases that we don't hear about where people have defended themselves and have in fact gone to jail or been fined or paid some penalty? How often does this situation crop up that we should worry about it?
I'm not able to speak to how common it is. I'm not aware of the stats on this, but I will say that the effect goes beyond the individual case. There's a chilling effect. At the start of this interview, you asked me about the message being sent to Canadians about whether or not they have a right to self-defense. And I think for a lot of people who see a case like this come into the news, the message they receive loud and clear is, I should be very hesitant to engage in self-defense. When I'm making that decision, I'm choosing between trying to defend my life or trying to avoid the possibility of criminal liability.
So really, the man who decides to throw the intruder out before he comes near his wife and his children will be the hero, because he's not only facing the intruder, he's facing all the possible consequences that come later.
Right.
What a sad situation. Hatem, thank you very much for shedding your wisdom upon this. I won't ask you to guess what's going to happen in the Lindsay case. There are still too many details that have not been made public, but certainly my sympathies are with the gentleman who has been charged with defending his home, and I think a lot of people watching this program will probably feel the same way. So thanks for explaining what's really behind this.
Thanks for having me on.
You're very welcome. For the Western Standard, I'm Nigel Hannaford. Good night.